Hi everybody, hope you're well. Welcome back to Law Hero, and it's Jen. So this is video number 2 out of 8 that we're doing for the FE1s. We're going to be doing 2 a week for the next 4 weeks. God help me. And yeah, tonight we're doing company law, so strap yourself in. It's going to be a bumpy ride. And yeah, I'm just going to get straight into it. So we have obviously Dr. Tom Courtney. Let me just see who the external person is. I think it's like Ray. Is it Ray? So remember, 3.5 hours, away we go. So the first question was an essay question, and I like this one because this would be one I would have loved to have done. While company directors have a fiduciary duty, remember fiduciary duty is kind of an equitable thing. So basically it's almost like the director is like a trustee of the assets of the company. Fiduciary means like he has to act or she has to act in the best interest of the company. Oh, look, to act in the interest of the company. They also have duty to have regard to the interests of other persons. So there's 2 parts to this. However, all such duties are owed to the company. So you basically have to look at fiduciary duty to act in the best interest of the company, and also duty of regard to other interests. So it's what duties are owed and to whom they are owed. And I would have answered it kind of half and half. A good candidate would have gone through the fiduciary duties, and obviously they would have spoken about statute like section 228, and then they would have gone through the different stakeholders, and my ebook goes through all of this. So shareholders, creditors, and employees and third parties. All right. So the question number 2 was a problem question. I'm not going to go down through it. So you have a number of shareholders, and then what basically happens here is there's a dispute around referrals, okay? And that's in disregard to their interest as a shareholder. And you're basically asked whether there's a remedy under section 212, which is shareholder oppression, and whether your answer would be different if the constitution or the shareholders agreement contained provision that the company would support a shareholder's business by referring clients to them. And yeah, you're supposed to answer both. So section 212, you would go down through all the case law there, and then you would apply it to the company shareholders to see actually is there oppression. Then you would cite what the remedy is. Then you would look at whether your advice would be different if they had provided for it in the constitution or the shareholders agreement, the difference being that the shareholders agreement is just kept off the company's house record. In the shareholders agreement, then they would have actions against each other, for example. If there's a shareholders agreement, it means they or if it's in the constitution, it means they decided that. So yeah, they will be bound by it. Question 3 is it's a classic essay question. It's been asked many times around corporate governance, which is it's recognised that members can sanction a course of action through resolution, general meeting, duly convened and held by unanimous or majority written resolution, or a stop created to the unanimous informal agreement. And I have done that in my ebook many times. Question 4 was a problem question. Directors, but it was a single shareholder. It seems that there are some connected people because there's the managing director's daughter and her husband. They're all section 220 connected people. Now things have started to go badly, so we can already guess this is probably going to go south, that there's going to be some problems with money. They're gone insolvent. They've been placed into creditors' voluntary liquidation. Company's record keeping was sporadic. Oh, we know what's coming now. It's probably a restriction. And oh look, you're asked about a restriction order and the defences. I mean, this is a classic question in the FE1 company law. Question 5 is an essay question, and I'm not even going to bother read the quote, but it's from Turquoine's case, and it says, talk about section 40 of the Companies Act, which is corporate capacity. Have a whole chapter on that. corporate authority, corporate capacity, section 38. So basically binding the company to certain courses of action and who's allowed to do that. Question 6 then was around section 602. That's a statutory example of the pari passu principle. Pari passu means in the same way, which requires all creditors of an insolvent company to be placed on equal footing and not to leapfrog the statutory queue. So the statutory queue obviously is super preferential creditor, which is like the revenue, and then you have preferential creditors, which normally could be a lender with the first ranking charge, and then you have so whatever other debt comes under that, so it could be like second lien debt, and then you have shareholders, and obviously creditors cannot sort out between themselves, like unless it's an intercreditor agreement. But other than that, when the company goes into insolvency, there is a statutory queue. Question 7 was a problem question. Now, this was an advantage and disadvantage of incorporation and the consequences of incorporation generally. And the tendency of most people is to go off on a tangent and just right verbatim what they know on incorporation. But I'm really pleading with all of you, if he gives an incorporation style question couched in problem question terms, as in there's facts, please stick rigidly to the facts in the problem question. Because like here, for example, like this person is a sole trader and is a plasterer. They plaster new houses and extensions. Recently, one of his employees narrowly avoided serious injury. And what he's getting at here is like the Health and Safety Acts, the fact that like Pat has unlimited liability here if something happens to one of his employees, because basically like he's the sole trader and they could come after him and say, you didn't give me health and safety training, like you don't even have insurance if something happens to us, that kind of thing. So he's better off being a limited company, because he could protect himself and his own personal assets. Like, this is just me speaking off the tip of my tongue. This other employee has been pressing Pat to give him an interest in the business, and obviously if you're a limited company, your shareholders can subscribe to you, which will bring in some investment, which might make things better. So yeah, like in the context of this, it would probably be a good idea for a plasterer. But then again, you have to talk about the tax implications of incorporating and stuff. So I hope you guys read all of that in my ebook. And you know, like we don't have a Corporate Manslaughter Act in Ireland. I've made a video on corporate manslaughter and white collar crime. You can check it out on my YouTube channel. But it's still, you know, you can be negligent as an employer, which Pat could have been here for not, you know, adhering to health and safety and, you know, equipping his employees with the right stuff. So yeah, he could be in big trouble. And as well, like if his dependents, like if his employees' dependents come after him and are like, that was the sole breadwinner in the house, like you have to pay us as well, he could be rightly screwed. Okay, so the last question is a problem question, question 8. So we have equal shareholders in the company established by their late mother. They received their shares under her will, blah, blah, blah. Oh, look, someone went to San Francisco. So already I can tell you this is probably going to be transfer shares. So the directors have a discretion whether to transfer shares. And I was like, this is important in a private company, because you don't want any old person coming into your private company. Like, that's the whole point of being private. If you want any old person coming into your company, you can float your company on the stock exchange or go public, so that shareholders can subscribe for the shares. So yeah, I mean, the first thing you would always do is check the constitution to see have they disapplied the directors' discretion not to transfer shares. That's the first thing you would do. And also then there's 2 months, like if the statute does apply, there's a 2-month limit. and all of that. Said is, I hope you guys had followed my company law during the summer, because the COVID-19 Miscellaneous Provisions Act 2019, or 2020 rather, that allowed certain, we'll say, derogations from the Companies Act. You know, there was things like having your, you know, your board meetings online, and there was stuff around dividends. Now, he didn't ask any dividends here, or he didn't ask receivership or examinership or any of that. So he probably will ask those the next time around, maybe in March. But just so you know, the COVID-19 2020 regulations have been extended to this June 2021. So like, if you guys threw that in at some stage to one of your questions, that would show a genuine interest in company law. So I mean, that would be kind of a tip to, you know, maybe give Tom Courtney a smile, you know, who knows. So yeah, again, lovely paper. There was nothing weird in there. I mean, the pari passu question might have threw a few people who were hoping for like retention of title, but he asked that back in August, I believe. So yeah, lovely paper. I hope you guys got on okay. From what I can see, not many people have come to me with it failed, but yeah, who knows, maybe out there might be a few people who failed it. So yeah, I hope you guys all are doing well and doing fine during COVID, and I will be back next week with I won't say what now, but I have 6 more to do. So yeah, stay tuned. See you in the next one. Bye.